those of you who are here today, it's good to see you in person. Most of our members are online. As you know, we were snowed out yesterday, and so many of them went home, and I encouraged them just to WebEx in. So we don't have a large crew in person, but it certainly looks like almost everyone is online. So good to see everybody online. Since we do have a quorum and we have some people here in person that could object if need be, and certainly if anyone online objects, we'll stop and won't do it either. But we're going to go ahead and do a request for bill introductions. Representative Featherston is here.
Thank you. So 22 RS 2675, an act concerning crimes, punishment, and criminal procedure relating to crimes against the public peace, creating the crime of interference with the conduct of a hospital, relating to battery, increasing the criminal penalty for battery of a healthcare provider, amending KSA 2021 Supplement 21-5413, and repealing the existing section. I'd like to say God bless the reviser who walks me through. So on this bill, I have somewhere between 15 and 20 co-sponsors, with Representative Kincannon being the secondary co-sponsor.
So my understanding is you're going to introduce that directly to the clerks, so it won't be a committee bill.
Okay.
Okay, does that work?
Yes.
We're all good with that. So that way those at home and didn't hear Natalie, or I don't even know if anyone could hear Natalie, but that way the co-sponsors' names appear on the bill itself, not that it's a bill from the committee. So excellent. Move on to your next one.
Number 2 is a committee bill, 22 RS 2746, an act concerning civil actions relating to the Protection from Abuse Act, Protection from Stalking, Sexual Assault and Human Trafficking Act, restraining orders issued pursuant to acts, time limitations, amending KSA 2021 Supplement 60-3107 and 60-31A06, and repealing the existing sections.
Now you know why nobody wants to be the clerk that has to read down there. Any questions, committee? Any objection? Very good. We will get that one introduced.
Thank you.
If you have any issues with the other one, let me know, or Natalie, and we'll walk you through on how to get it turned in.
All right. Thanks so much.
Awesome. Anyone else with a request? Just a reminder, Monday is our deadline, so you've got one more chance on Monday to request a bill, at least through this committee or any other non-exempt committee. We will now move on to our bill hearings. We have 2 today. I'll open the hearing on House Bill 2538 and have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2538 would modify the time requirement for holding a preliminary hearing, and it allows for testimony to be presented through two-way electronic audio-video communication. The bill amends KSA 22-2902. That's the statute that gives every person charged with a felony the right to a preliminary hearing. Current law requires that preliminary hearing to be held within 14 days after the arrest or the personal appearance of the defendant. This bill would change that to require the hearing be held within a reasonable time after arrest or personal appearance. Current law also requires that witnesses, except those under 13 years of age, be examined in the presence of the defendant. This bill would remove that requirement and allow both the state and the defendant to present testimony of a witness through two-way electronic audio-video communication devices. And then finally, the bill would allow hearsay evidence to be admissible at a preliminary hearing. And I can take any questions.
Questions for Natalie? Representative Carmichael.
Thank you, Mr. Chairman. I can't remember whether video testimony, as I recall, was offered in this committee last year, at least for, I believe, civil actions, and And as I recall, it met with a lot of trouble in our committee. I may be wrong on that, but didn't we stop, if you will, the use of two-way video testimony or proposal to do that in civil cases last year in this committee?
Mr. Chairman, Representative Carmichael, you did have a proposal related to allowing testimony in civil procedures through the use of two-way audio video recordings that came from the courts. You also heard a bill related to the Chief Justice's ability to authorize it during the state of disaster emergency during COVID. But I think that the bill that you're talking about is the one related to civil actions.
And what fate did that bill related to civil actions meet in our legislature last year?
It didn't pass, but I would have to look up the exact, I recall you guys debating it on the floor, but I don't remember what happened after that. So either Bob might be able to track it down real quick, or I can look it up when I sit back down.
And perhaps I may even be thinking years before, because as I recall, our former member, now Senator Warren, was strongly opposed to the bill. My second question, in your brief, you indicated that all defendants have a right to a preliminary hearing, I think. Now, I know at least in some statutory schemes, if you are indicted by means of a true bill from a grand jury, there is not an opportunity for preliminary hearing. As it stands right now, is there a right in instances where there has been a true bill indictment through a grand jury? And if so, does this change that?
Mr. Chairman, Representative Carmichael, no. If you look starting at line 10, so every person charged with a felony shall have the right to a preliminary hearing unless that charge has been issued as a result of an indictment by a grand jury.
Thank you. I'm sorry, I must not have heard that part as you were presenting the bill. And finally, this matter of allowing hearsay, I think we've seen that before in this committee on at least a couple of occasions, and I don't think it ever even made it out of committee. Do you have a recollection as to when the prosecutors have tried this before and what the outcome of their efforts has been?
Mr. Chairman, I don't remember specifically anything related to hearsay evidence at a preliminary hearing, but I will double check that when I sit down.
I think it may be covered in Ms. Roth's testimony, which I just received a few moments ago. I think it was back in 16 or 17 that we had quite a long hearing with an assistant district attorney along with Ms. Parker, where we discussed the merits of abolishing the so-called hearsay rule in preliminary hearings. So I'd appreciate if we could look, because I think we've been down this road before. Thank you, Mr. Chairman.
Representative Hoheisel.
Thank you, Mr. Chairman. My question is on the reasonable time after the arrest. That seems very, very subjective as far as reasonable time. Do we use reasonable time to describe any other time frames when it comes to criminal proceedings or anything like that?
Mr. Chairman, Representative Hoheisel, we do use a reasonableness standard somewhat frequently throughout the criminal code and the criminal procedure code. I would have to look specifically as it relates to time frames, how often we use reasonableness as a standard when it comes to a time frame.
Thank you, Mr. Chair.
Any other questions for Natalie? Representative Carmichael.
Thank you, Mr. Chairman. So following up on the representative's question, if we eliminate a 14-day requirement, which is present law, and we say instead a quote-unquote reasonable time, how long will someone have to sit in jail before they finally get a preliminary attempt to prove their innocence so that they can be released because the judge finds no probable cause? How long will people have to wait in jail under this statutory scheme, knowing that they now at least have a right at 14 days to have a determination by a judge?
Mr. Chairman, Representative Carmichael, I wouldn't be able to answer the question how long they'd have to be in jail, because there's a lot of other provisions, related to bond, a lot of other opportunities for the defendant to not be in jail while they're awaiting a preliminary hearing. But your point is well taken. We're changing 14 days to a reasonable amount of time, and I'm not sure what exactly that reasonable amount of time would be.
Clearly, I'm not talking about a bond hearing here, which generally takes place within 72 hours, if I recall, or maybe less. I'm talking about people who can't make bond and they're rotting away in jail. It looks to me, Ms. Scott, that we're taking away a hard and fast 14-day deadline, which, by the way, is oftentimes continued by the agreement of the parties. But we're taking away that right of citizens and substituting it with an open-ended determination based on whenever the prosecutor and I guess the judge get around to it. Thank you, Mr. Chair.
Back to Representative Hoheisel.
Thank you again, Mr. Chairman. Natalie, the 14 days, who is the reasonable time? Who's that up to? Is that up to a judge to decide what a reasonable time is?
Sure, Mr. Chairman. So the statute would now read that the preliminary examination shall be held, within a reasonable time. So the judge, on appeal, if someone were to be convicted and then appeal their sentence and say that my preliminary hearing wasn't held within a reasonable time, then, it's going to be up to the judge to determine what a reasonable amount of time is.
Got it. Thank you, Mr. Chair. Thank you, Natalie.
Any other questions? Thank you, Natalie. We'll move on to proponents. And first I have Brett Watson, the Shawnee County District Attorney's Office.
Good afternoon. I'm happy to have the opportunity to speak in favor of the bill today, and I have prepared written testimony which I have submitted to the committee. I don't want to belabor the point raised by the written testimony and go through that point by point. What I'd rather do is speak in a little bit more of an open-ended way about why I believe that this is a good piece of legislation and one that will be beneficial to all parties in a criminal proceeding. The primary thrust of the legislation, as was noted just a few moments ago, is to change the rules of evidence at a preliminary hearing. In Kansas, for felony offenses, a defendant who is charged by complaint, not indictment by a grand jury, but by a complaint, is entitled to a preliminary hearing, and at that hearing, the rules of evidence apply. However, the thing that the court is looking for at a preliminary hearing is not proof beyond a reasonable doubt or even sufficient evidence to show that it is more probable than not, or there's a preponderance of the evidence that a defendant has committed a crime. But rather the court is looking for probable cause, and that is evidence which would make a reasonably conscientious person entertain a notion as to the defendant's guilt. At a preliminary hearing, the court is required to look at the evidence in a light most favorable to the state and draw all reasonable inferences in favor of the state. The standard is not a particularly high one, although the preliminary hearing is a meaningful proceeding. However, there are certain realities that go into doing what are essentially miniature trials at a preliminary hearing. And one of the most important ones, we believe, is the cost in terms of time and expense of bringing witnesses in. One of the things I alluded to in my written testimony is that there is a certain amount of gamesmanship that goes along with preliminary hearings. In my personal experience working at the Shawnee County District Attorney's Office, where I am now the Chief Deputy District Attorney, when I started working at the District Attorney's Office, I was what we call a second chair attorney, and the caseload that I handled was mostly low-level felonies. These would be crimes such as theft, drug possession, things of that nature. In those cases, it was frequently the case, and this has been my experience in prosecution throughout the state, that in order to prepare for a preliminary hearing, the state must subpoena witnesses. And in many cases, there are multiple witnesses who must be brought into court to give testimony. Once we get to the preliminary hearing, however, it is very typical for the defendant to waive the preliminary hearing. The unfortunate thing about this is that we end up bringing in, say, 3 police officers for one preliminary hearing. That means their agency has to pay them to be there, and their testimony or their being present is required because there may be some small piece of evidence or important piece of evidence that can only be brought in if they're present and available to testify, and they actually testify. On the other end of things are major cases, and I can give you sort of two examples of those, and they, I think, help illustrate why I believe this is a good piece of legislation. One of them is a case that I alluded to in my written testimony where we had a preliminary hearing in a theft case. This involved a family who had traveled through Topeka on vacation. As a matter of fact, the gentleman in question, the victim of the crime, had told me that his family was here to visit the Topeka versus Board of Education historical site. They were stopped at the mall. Their car was burglarized. They made a report of it to the police. The defendant was arrested, and then they continued on their way throughout their vacation. So when it came time to set the preliminary hearing, we couldn't do so immediately because we had to get a witness from the state of Ohio, which we eventually did. So this person had to take off of work, travel to Kansas. We had to pay the travel expenses for this person to come here. When he arrived, the defense attorney told me that they would waive the preliminary hearing. The advantage to this kind of piece of legislation is it would allow us to proceed with probable cause hearings by admitting that victim's statement at the hearing without the victim necessarily having to be there. This is essentially how we would proceed if we took the case to the grand jury, because a defendant would have no right to be present, and the grand jury would simply consider that information when it determined whether or not a probable cause or whether there was probable cause to bind the defendant over for trial. Yesterday, interestingly enough, I had a case that was set for preliminary hearing. It was an attempted murder case where we had 26 witnesses, and up until the day before the hearing, we'd found out about 5 of those witnesses were not available because of illness. This was a case which was somewhat complicated in terms of identifying the defendant because it required us to use multiple videos throughout the city of Topeka. And so with each video that we had to admit, we had to bring in a witness who was a civilian. We had to subpoena them. They had to take time off of work. They had to come into court. We had to present their testimony for essentially this question: do you own a security camera, and was it working on this date? Because that's the foundational requirement for the admission of that kind of evidence. Without that witness, we can't admit the videotape, and we can't present that witness's statement that their video cameras were in working order on the day in question without them being present. But under this legislation, we could proceed under those circumstances through the testimony of an officer who collected the video, who could say at a preliminary hearing, the witness told me that they had security cameras and they were in proper working order. I think that's one of the examples of the kind of efficiencies that this bill would help to introduce. I'm talking about it from the perspective of the state, however, and I think it's important to emphasize that the rule that allows the introduction of hearsay is not just beneficial to the state, but it is also beneficial to criminal defendants at probable cause hearings, because defendants are bound by the same rules of evidence that the state is bound by. And so if at a preliminary hearing, the defense wants to put on evidence that might mitigate against a finding of probable cause or be favorable to the defense, if it involves the testimony of a witness, a declarant who is not present, then that testimony is inadmissible. But under this legislation, at a preliminary hearing, a defendant would have the same opportunity and right to present favorable evidence to the court in the form of hearsay evidence or hearsay testimony. So that, I think, is in essence the point that I want to try to emphasize for the committee. As we have pointed out, or as I've pointed out in my written testimony, Kansas, I believe, is a bit of an outlier in terms of the procedures that are used for a probable cause determination. When a defendant is arrested, there is a probable cause determination made by a judge within 24 hours of their having been arrested. And that is what the U.S. Supreme Court says is all that is required constitutionally for that determination. And that is, if a defendant is arrested, then a court will review an affidavit that is attendant to an arrest warrant. And based upon that, which is entirely hearsay, the court will determine that there's sufficient probable cause in order to hold the defendant, that is, to arrest the defendant and hold them for charges. Kansas, however, has a much more onerous procedure as far as the preliminary hearing is concerned than some other states do. And as a matter of fact, one of the things that we point out is the legislation that is proposed in this bill essentially models the language from the state of Wisconsin. And in my research on this issue, especially when it relates to the grand jury, a great number of states permit hearsay either at preliminary hearings or during grand jury proceedings for a probable cause determination to be made. So my submission to the legislature and to this committee is that this law will actually bring the state in line with the majority of other states and the procedures that they use to make probable cause determinations at preliminary hearings. I think when you consider the efficiencies of the law, and you consider especially now at this point in time with the difficulties that this committee is facing with having its members personally present in the hearing chamber to listen to proponents and opponents of legislation, you must imagine that the courts are under enormous pressure as well. We have so many situations in which preliminary hearings end up not being able to go for one reason or another because someone has become ill. They can't physically come to court, but they could come to court remotely, or their testimony or statements could be admitted through the testimony of another witness who took their statements. For those reasons, I would urge passage of this legislation, and I will answer any questions you have.
Questions, committee? Representative Carmichael.
Thank you, Mr. Chairman. Some years ago, this committee heard very similar testimony from a representative of the Shawnee County District Attorney's Office. Was that you, or is that somebody else at the office who testified previously on basically the same proposal?
No, it wasn't me, Representative. I believe it was the Chief Deputy District Attorney, Dan Dunbar.
That sounds exactly correct. I wish Mr. Dunbar could be here today to help remind us of what happened the last time we heard this bill. But as I recall, when I asked Mr. Dunbar if he agreed with Professor Whittemore that cross-examination is the greatest engine for the detection of truth ever invented by man, or words to that effect, he reluctantly agreed. Would you agree that cross-examination is the greatest engine for the detection of truth ever invented by man, or would you see it differently?
No, I would absolutely agree with that. And I think that's why the Constitution gives a criminal defendant that right of cross-examination at trials. I do believe there are some different things in play when we're talking about preliminary hearings, though.
And right now, if the state proceeds by grand jury indictment in a true bill, as Ms. Scott, I think, explained, there is no preliminary hearing or right to preliminary hearing in Kansas. Is that correct?
That is correct.
However, when the state proceeds by what's known as complaint and information, and I hope that's still the term because I was talking to one of your colleagues in the defense bar this morning and realized it had been 40 years since I've drawn up a complaint information. But what's required there is a criminal complaint and that information be provided to the judge by way of hearsay, typically just a statement from the investigating detective that establishes that a crime was committed and that there's a probable cause or reason to believe the defendant did the crime. That's the way these cases that we're talking about here first come into the system. Is that correct?
If I understand your question, and I think I know what you're talking about, and if I understand your question correctly, then the answer would be yes. A criminal prosecution is commenced, if not by grand jury, then by the filing of a complaint. In most situations, although not all, but in most situations, it's commenced upon the filing of a complaint and the request for a warrant. when a warrant for the defendant's arrest is requested, that must be accompanied by an affidavit, which is a sworn statement by some person, which is usually the lead law enforcement officer investigating the case, which lays out the evidence that would establish probable cause to support the arrest of the defendant.
So a court has already made a determination of probable cause based on police reports before we get to the preliminary hearing stage in these cases. And what you propose to do is simply to have the court sit down again and let the investigating detective say, Officer Jones talked to Mrs. Smith and she saw somebody that looked like the defendant breaking into the house. And then perhaps I was also told by Officer Williams that another lady down the street, Mrs. Carmichael, also saw somebody looking like the defendant breaking into the house. And that hearsay upon hearsay would be sufficient to establish probable cause to believe that the defendant that a crime had been committed and that the defendant committed the crime. And at that point, the state has fulfilled its burden based on hearsay upon hearsay, perhaps even upon hearsay, but that's good enough for the Shawnee County District Attorney's Office. That's all the rights that you believe that citizens in Shawnee County should have, correct?
Well, no, I would not accept that characterization completely, sir. I mean, I would point out that the meddlesome or the troublesome scenario that you talk about, hearsay upon hearsay, is the thing that the U.S. Supreme Court says is required in order to support the arrest of the defendant. The reason why, in constitutional terms, that we have preliminary hearings in the first place is a procedure that is essentially there for justifying the seizure of the defendant's person under the Fourth Amendment. But as I noted before, the U.S. Supreme Court has said the mere review of an arrest warrant is sufficient to satisfy that right. There is another thing that I would take issue with as far as that description is concerned. In practice, I can tell you, we have a grand jury in Shawnee County, and we do use it frequently. The kinds of cases that I prosecute, which are homicide cases as well as sex offenses, mostly against children, very rarely go to the grand jury. I almost always insist on preliminary hearings. The reason why I think this piece of legislation would be helpful is not because it would help the state to eliminate ever having to bring a live witness in to testify. There are many incentives for the state to do that, and I frequently do that in my own practice. But I think what the issue is, if you have, for example, a DUI case, and you have an officer who arrests the suspect and who observes them driving in what they appear to be an impaired fashion, but you also have to call in another officer to testify about the intoxilizer being in proper working order. Whereas it would be efficient to present that testimony through hearsay, there's an efficiency in allowing hearsay for that reason. The determination about probable cause in such a scenario is very likely to be made. In examples such as the case I was talking about that I had yesterday, an attempted murder case, the victim was going to come in and testify. He would be in front of the defendant. He would be subject to cross-examination. The eyewitnesses would also be there, and they would be subject to cross-examination. But this piece of legislation would be helpful and efficient, I think, because of the 5 witnesses that I need to bring in to say, yes, I had a video camera on such and such date, and yes, it was in proper working order. We could proceed to a preliminary hearing without necessarily having those people there. And one other thing that I would like to emphasize is, as I said a moment ago, there are benefits to a defendant in having this legislation in terms of being able to introduce their own hearsay. But there are also benefits just in terms of this. If a preliminary hearing does not require, if a case like the one I had yesterday, which might require 26 witnesses, would only require 15, it's more likely that the preliminary hearing can happen at a quicker time because the court doesn't have to look for an entire day setting. It can look for a half-day setting or a 2-hour setting. And that means defendants don't have to wait as long until they get their preliminary hearing. In the case that I was talking about that finally went to preliminary hearing yesterday, we had waited about 8 months before we got in front of the court. Now, part of that delay had to do with a request by the defense for a continuance, but part of it also had to do with the fact that at one point when we had scheduled the hearing, one of our witnesses, who was an essential eyewitness, could not appear because they were ill. But if we have a situation in which those witnesses could either testify remotely or their testimony could be admitted through the testimony of another officer, and the court could consider hearsay, defendants would get their probable cause determination made at a much earlier time, and their cases would move faster to trial and ultimate resolution. So I see a benefit to the defendant rather than impinging upon their rights.
You forget, sir, that not all defendants' cases move on to trial. Mr. Chairman, I have many other questions for this witness, but he's pretty adept at telling war stories, so I'd like to have someone of my colleagues have their opportunity. If time permits, I have more questions for the Assistant District Attorney.
Representative Humphreys.
Thank you, Mr. Chairman. Thank you for being here. You may have just touched on my question, but looking through your testimony, it's mostly about the hearsay. So did you speak to the video communication and the reasonable time?
Not to a great extent. If you have questions about that, I'm certainly willing to address those.
You're a proponent for all three of those?
Yes.
But the main thing in your testimony had to do with the,
Hearsay,
yep,
yes.
okay. I mean, would you like to expound on that just quickly, those other two issues, or?
Certainly. As far as the reasonable time is concerned, there is a section in the current preliminary hearing statute that requires the hearing to be set within 14 days. By case law, or at least in my research, I've never seen a case in which a violation of that 14 days was reversible error. That is, it doesn't appear to be an error that a defendant can complain about on appeal and get some kind of a remedy. I think that, well, let me say it this way. In my experience, I don't know if I've ever seen a preliminary hearing that has been scheduled within 14 days. Now, part of the reason why is because when defendants are initially brought before the court for their first appearance and they have an attorney appointed, the defense attorneys want more time than 14 days so that they can obtain discovery from the state. But it just seems, to me anyway, it just seems sensible, since that is really not a rule that is being followed, to change it to a reasonable time, which is a standard that we use in other areas of criminal law, most especially, I believe, in terms of the service of discovery of, say, expert witness testimony. I believe the statute in that instance indicates that that must be exchanged or turned over to the opposing party within a reasonable time. As to the two-way telecommunication, I believe I touched upon that briefly in my written testimony, but I believe that there's an obvious benefit to allowing us to proceed in such a way. During COVID, there were, during the period of time in which the courts were shuttered, when they were beginning to reopen, there were a great number of hearings that were conducted in that way, and not just preliminary hearings, but hearings of all sorts. And that primarily, or not even primarily, but that included hearings where defendants didn't even appear in person. But permitting, I believe, a preliminary hearing where certain witnesses are allowed to testify remotely would help solve the problem that I was talking about before of what happens if you have a witness who is from out of state, someone who has a crime committed against them while they're traveling through Topeka or Wichita or Garden City, Kansas. And for them, it would be an enormous inconvenience to have to come back to attend a preliminary hearing, but they can give their testimony remotely. It would also help, I think, to alleviate the problem that we're seeing more and more in the court, which is we have a hearing, it's scheduled for a long time, but the day before a witness is quarantined because they have COVID symptoms. And in many cases, they're well enough to testify, but they're simply not allowed or not capable of physically coming to court. So I believe that that would be a benefit. And also, like I was alluding to a moment ago, I think a benefit for all sides. Because delay is not good for the state, but delay is also not good for criminal defendants. And so whenever preliminary hearings can go and we can remove obstacles to them actually happening, I think that's efficient and that's for the best.
Okay, thank you. Thank you, Mr. Chairman.
Representative Carmichael, Natalie has an answer to one of your early questions.
Thank you, Mr. Chairman. So I did a little bit of digging. The 2020 bill about audio-video communication from the courts, that was House Bill 2447. The only criminal procedures that would apply to would be arraignments when the defendant is mute or is entering a not guilty plea. So it wouldn't apply if they were going to plead guilty, and then other non-evidentiary hearings. So the rest of the provisions were all civil or juvenile. Those were the only two criminal provisions implicated. That died on Senate general orders. So it did make it out of the Senate Committee on Judiciary, but it didn't make it above the line. As
Thank
for
you.
previous, oh, sorry, did you have a question?
I just said thank you.
And then
Thank
on
you.
the other issue, for hearsay evidence, back in 2016, Senate Bill 327 was introduced. That bill never came over here, but in 2017, you guys did hear House Bill 2259 that would have allowed hearsay during preliminary hearings. You had a hearing in this committee, but the bill didn't make it out of committee.
Thank you. That is consistent with my recollection. Thank you, Mr. Chairman.
Okay, any other questions before we go back to Representative Carmichael for a question or two?
Mr. Chairman,
Oh, Representative Wheeler. Representative Wheeler, you were unmuted for a second, but you're muted again.
my WebEx didn't work, so I had to come through the browser, and I have no hand to push to raise, so I just used my own.
That's Representative Hobson saw your hand way across the room. I could not see it with you in my face. So wave away. You're up.
Okay. Well, I just want to take this opportunity first to say hi and hello to my good friend and former Assistant Finney County Attorney when I was County Attorney of Finney County. So hello, Brett Watson. I wish I was in the room to shake your hand. And
Thank you, sir.
I think you're welcome, sir. A lot of the questions I have may be asked and answered, and some even beaten to death. But I do have just a simple question of the use of hearsay. And I think most in this room, and you can give a definition of hearsay if you want to. Brett, would you do that?
Hearsay is a statement by an out-of-court declarant admitted for the truth of the matter asserted by the statement itself.
Okay. So you made reference to a witness whose statement was introduced at a preliminary hearing. You made reference to that. There are a lot of witnesses who don't make written statements. What about a detective's written statement of an interview that he or she had with a complaining witness? Would that be admissible under your proposal?
Yes, it would. That would fit the definition of hearsay, and under the legislation, the change indicates that the court may make its determination based upon hearsay in whole or in part.
The reason I ask that question is that it's not only hearsay, it's double hearsay. And I want to know how far we're going to extend the hearsay rule by eliminating it.
There essentially wouldn't be a limit on the admission of out-of-court statements under this legislation. So the example that you're talking about, a detective testifying about having interviewed a witness and this is what the witness said, that could be admissible at a preliminary hearing without the witness in question, without the eyewitness actually being present. Which is very similar to what happens in a grand jury probable cause determination, where a detective comes before a grand jury and gives testimony that a particular person made a statement, and that's put in front of the grand jury for their consideration.
And one further, if I may, Mr. Chairman. If this should pass this committee, what effect would it have on alleviating backups because of the pandemic?
It's my opinion, at least from my experience in Shawnee County, that it would have a very helpful effect in eliminating that sort of thing. And I don't know if it's consistent throughout the state. I don't practice in other jurisdictions, but I can tell you what's happening in Shawnee County. From March of 2020, we stopped doing trials, and for a significant period of time. In that period of time, crime, especially serious violent crime, did not stop, but it continued. And so during that period of time, we could not do preliminary hearings for murder cases, rape cases, very serious offenses. And we couldn't do jury trials for all the cases that were waiting to get started. In the last 12 months, I think it was last spring, we actually started in earnest doing jury trials in Shawnee County. We started with doing trials where the crimes had occurred in 2018. And right now, as we're in 2022, I personally am working through the backlog of cases that happened in 2019. And so the problem that we have scheduling-wise is that the courts now have a bunch of defendants who are all waiting to get in line for trials. And so they have to set trials, and those trials get set now out until October or November. But in the meantime, we still need the court to remain open and have time available to do the preliminary hearings in the cases which have not yet been filed. And this includes major cases. The average time for a preliminary hearing in a run-of-the-mill murder takes about a day to do. In some other cases, which may be complicated, like robbery cases, sex cases, it takes half a day to do. So the court needs to be able to schedule those times. The problem that we're running into is, and interestingly enough, as we were standing here, I just got an email saying one of my most important witnesses for an all-day murder trial, or prelim, which is set for tomorrow, now has COVID and will not be able to appear. And so this has happened frequently where we've gotten to the eve of a trial, or a prelim, excuse me. The court has set aside this time, like a day or a half a day, and for one reason or another, usually it's related to COVID, it can't go. So that half day or that day is gone. The court can't get that back, and the court can't backfill that with new hearings. But another day or another half day needs to be gobbled up at some point in the future. And that means somebody else who's waiting for their preliminary hearing doesn't get it on that day. But if we are able to go forward on my preliminary hearing tomorrow without that witness, or if we could introduce that witness's statement through the use of hearsay, or even two-way telecommunication, then that hearing goes tomorrow. And that means that I don't need to reschedule this hearing and take up another day of the court's time at some point in the future. That day is available to hear perhaps 5 or 6 other preliminary hearings. I hope that addresses your question, sir, but I think that that's what I'm trying to explain, is that is what I see as the efficiency in this approach.
Would you object to having a sunset on this for, say, 3 or 4 years just to see how it works out?
No, I believe that that's the prerogative of the legislature, and the legislature is always experimenting with ideas. I think after a period of time, after review, I think what the legislature would find is that this law would be used in the way that I say it would. I don't think prosecutors would wholesale have preliminary hearings where they're farces or kangaroo courts. I think that they would be used judiciously for efficiency purposes. But no, I think perhaps a sunset provision would be wise, because it would give the legislature the opportunity to have some empirical evidence and see if they believe that it's a good idea in the long run. And I believe that it would be.
Thank you, Mr. Watson. Thank you, Mr. Chair.
Okay, we're going to go back to Representative Carmichael.
And I'll try to do it in 2 questions. I appreciate your forbearance, Mr.
Thank you.
Chairman. Let's return to the distinguished former prosecutor, Baird lawyer, and fine representative from Finney County's question about double hearsay. It appears to me, Mr. Walker, is it, that this bill permits far, far more than hearsay upon hearsay or double hearsay. It permits quadruple or more hearsay. Let me give you a very specific example. Let's say that my neighbor, Annie, who lives next door, she is out of the state about 6 months of the year. She sees somebody breaking into my house. She tells the investigating police officer, I think it was the next door neighbor, little Bobby, who broke into John's house. The investigating officer tells the detective that Annie told me she thinks it was little Bobby what done it. As I understand it, under this proposed law, there wouldn't even have to be a statement from Annie, the person who actually saw it. There wouldn't have to be a statement from the police officer. All there'd have to be is a detective that comes in and says, you know, Judge, I talked to the investigating officer on the scene, Smith, and he told me he talked to Annie, and Annie said it was little Bobby that done it. And that's all that would be required to bind little Bobby over for trial on a burglary charge. Is that really the system of justice that Shawnee County DA is advocating for?
Well, I suppose, yes, the answer to your question is yes. I think implicit in that question is the idea that there's something outrageous about doing things in that way. And that's one of the points that I'm trying to emphasize, is that there are many other areas of the law where that scenario that you're talking about would come about. What you're talking about is a scenario where a detective either tells the court in oral form or in written form that a police officer interviewed an eyewitness and the eyewitness's account indicated that the defendant had committed the crime, is the basis by which we exercise the power to arrest people and hold them in custody. Through the grand jury, that same kind of testimony could be used if heard by a grand jury and if it was persuasive to them to find probable cause to indict a defendant, which is the same function as a preliminary hearing, and cause them to stand trial. I think it's also important to recognize, and this is one of the reasons why I mentioned the law in other states, that this exact same procedure is used essentially to make probable cause determination to bind over others in other jurisdictions and have them face trial. In terms of the example that you use, sir, I would agree that yes, that would be permissible under the law. I don't necessarily believe that that's such an outrageous affront to justice, though.
So, for example, if, to continue this sad story of the burglary at my house, I'm the attorney for little Johnny or Bobby or whoever it is that's the accused today, and I want to cross-examine Annie, the eyewitness, because I want to point out to the judge that Annie, the eyewitness, is blind in one eye and has 2500 vision in the other eye, but she's down in Texas. How in the world do I get my client released from jail if I can't cross-examine the eyewitness who's 3/4 blind, who identified my client as being the one who broke into John's house? How am I going to do that when she's 1,000 miles away and you've already fulfilled your burden based upon hearsay upon hearsay upon hearsay? How's that going to work?
Well, I think that this is one of the things, like I've said earlier, that I would emphasize about the bill being useful to defendants. I understand your hypothetical, your scenario, but if in fact there was evidence indicating that the eyewitness Annie was blind in one eye, had perception problems, that is something that a defendant could admit without having to call a witness at a preliminary hearing. It is also important to remember, however, that if the evidence were to come in even live from Annie in person, if the evidence were presented as you have described it under the prevailing standard, that which the court follows, the defendant would be bound over for trial, because the court would ultimately have to determine that the credibility of Annie's identification of Bobby as the assailant is ultimately a question for a jury to resolve at a trial. However, if it were the case in your scenario that Annie did not admit to being blind in one eye or had these health problems, but other witnesses said that she had them and they were not present and Annie was, a defendant would not be able to present that evidence for the court to consider at a preliminary hearing, except that they could through the admission of hearsay evidence.
But as you point out, and this is my second and final question, but as you point out, sir, number one, I don't agree with you that her hearsay statement standing alone could not be found by a judge to be less than credible if I had a chance to cross-examine and say, Annie, wouldn't you agree that you've been blind for 40 years and that really all you saw was somebody in a red coat, and that red coat looks like a red coat that you know belongs to little Johnny? And at that point, the judge might well find that there's not sufficient eyewitness identification and might not bind the defendant over. But the question then becomes is, how does it do any good to give a defendant a right to cross-examine? If Annie is down in Texas, I can't find Annie. I don't know where Annie is. But the cops say that she says that little Johnny did it. And I can cross-examine and call witnesses all I want after the fact. But as you say, the bar is very low. The facts and all of the inferences from the facts are taken in favor of the prosecution. So I think you just offer the defendant, if he can't cross-examine the witnesses against him, calling other witnesses that he may or may not be able to find and that still don't overcome the very low burden, that accomplishes nothing. It takes cross-examination of eyewitnesses to do justice. I don't expect you to agree with that, but I'd be happy to hear your comment. Thank you, Mr. Chair.
Well, I don't disagree with what you're saying, sir, and I don't want to give this committee the wrong idea about my feelings about the criminal justice system. And I don't mean by being a proponent of this legislation to say that we should have a system which empowers the state to do whatever it wants to defendants. I agree that cross-examination is vitally important in our criminal justice system, but the determination of guilt is one that is essentially to be made at the time of trial. The reason, like I say, we have a preliminary hearing is because the U.S. Supreme Court has told us that we have to have some kind of procedure to justify the seizure of a defendant, that is, their arrest or their being held by the state. But the parade of horribles that you talk about, with Annie talking to the police, talking to the detective with failing eyesight and then moving 1,000 miles away, are the kinds of examples of things that can still be used to justify the arrest of a defendant, to justify the issuance of an arrest warrant. I think one of the other things to keep in mind is that despite what some people might think about prosecutors, we don't aimlessly chase our tails on pointless cases. We make a determination about whether or not we, at least at the Shawnee County District Attorney's Office, should even charge a case from the get-go. But the reality of what we're talking about under this piece of legislation, I think, are situations where defendants are not going to be denied their right to cross-examine the critical eyewitness against them, but rather witnesses whose testimony is a fait accompli from the get-go. Somebody, for example, who can come in and testify that an intoxilizer was working, or a foundational witness, or something along those lines. So I agree with the representative that cross-examination is important. I would not propose in any way the defendant not be allowed to cross-examine the witnesses against him when guilt is decided at a trial. But I think considering the realities of the situation right now, and especially the law in other jurisdictions, this legislation is still a good reason or a good idea, beneficial to the state and the system in terms of efficiency, but beneficial to criminal defendants as well. If there are other questions, I'll answer them.
Asking questions of this witness as he continues to go on and on, but I think in the interest of time, I will leave it where it is, because it's clear that he's going to testify about anything and everything else under the sun here if given the chance. Thank you, Mr. Chair.
Any additional questions, committee? Representative Schreiber.
Thank you, Mr. Chair. Just quickly, did I understand at the start of your testimony that this was a language that was similar to a law in Wisconsin?
That's correct.
And what has been their experience in Wisconsin with this? Are you familiar with that?
I'm familiar with case law decisions from Wisconsin holding that the law is constitutional.
But as far as in practice, have there been numerous examples of people being held, and I'm not going to use the right terms, but unjustly being arraigned for crimes based on hearsay evidence and so forth?
Honestly, I can't answer that question because I simply don't have the information. I don't have any contact with practitioners in Wisconsin.
Okay, thank you. Thank you, Mr. Chairman.
Any further questions? Okay, thank you, Mr. Watson.
Thank you. I appreciate the opportunity.
Mike, you're just here for moral support, or you want to come on up? Your call. Okay. We'll go right on past that unless someone takes advantage of it. We have written proponent testimony committee that's been emailed out from the Kansas Coalition Against Sexual and Domestic Violence, and the also Sherry Shuck on behalf of the Kansas County and District Attorneys Association. Anyone else as a proponent here or online? Okay, I don't show any neutrals. Do we have any neutral? If not, we will move on to opponents. And first on my list is Jennifer Roth, and she is on WebEx.
Hi, Mr. Chairman. Can you hear me, see me?
I can hear and see you. You've successfully got in.
All right. I was a little worried. My name's Jennifer Roth. I am here today on behalf of the Kansas Association of Criminal Defense Lawyers. And I, by way of how I am aware of this sort of topic, I was a trial level public defender for 13 years in Shawnee County, where I had cases against the formidable, brilliant man you just heard from. I'm also an appellate lawyer now. So I have about, 8 or 9 years of appellate experience. I have testified about this provision before in 2016. And so some of my testimony might look familiar because we also submitted it in 2017 to this committee. At any rate, I apologize for the length of my testimony, but it was my concern that before you dismantle this process of how we conduct preliminary hearings, that you have access to as much information as possible. So I'm sorry for the case sites, but I see that Mr. Watson had some of the same ones. So at any rate, I do address the 14-day provision, which is something that wasn't in the past bills. I do address that in my written testimony. And I wasn't going to say much more about that, although I would concur with Mr. Watson that I could not find but one case in the last 45 years where the state, lost a case because they didn't have a prelim within 14 days. It doesn't happen. Finally, I don't really discuss in my written testimony the two-way the witnesses, testifying remotely. But I do want to talk about that here in just a second. So I have just a couple of concerns I wanted to highlight beyond what is in my written testimony. And one is that I heard Mr. Watson say a number of times that some of the problems that he sees and that we see across the state could be mitigated and solved in large part by having people testify remotely rather than having, just admitting hearsay. I heard a lot of instances of if you did this or this. So I guess my first comment is that the situation with the man traveling through Kansas back to Ohio, the people with the security cameras, those things could be solved if just the third part of this bill is passed that would allow for remote testimony and preserve the hearsay, the prohibition against hearsay. We could still solve the problem that he's identified. The second concern I have is I was happy to hear Mr. Watson talk about grand juries. That's the most I've ever actually heard about them because they are conducted in secret. And I guess he confirmed what I always suspected, which is that there are law enforcement officers who are reading reports of their own and other people. And one thing that I'm concerned about is that if this bill passes in its form and allows hearsay without limit, that we will just turn into prelims will become like grand juries. We'll just get to be sitting in the room watching the people read the reports, but that they will not serve all of the functions that preliminary hearings currently serve and the things that I try and outline in my testimony. So I'm not one bit interested in having this turn into a system where we just watch a functional equivalent of a grand jury. And I guess I just want to interject here that I practiced against Mr. Watson, and not everybody is Mr. Watson. And so I appreciate him speaking for himself and his office, but I don't believe we can guarantee that across this state that some of the concerns that we have wouldn't come to fruition. Another point I wanted to make is that I'm a little bit concerned about some of the language that folks used in their written testimony, and like when we talk about efficiencies or things like that. These folks at the preliminary hearing stage are constitutionally supposed to be presumed innocent, and these are folks. And so I'm a little bit concerned about when we talk about efficiencies and things like that, because this is a preliminary stage. Which kind of leads to my other point, one of my many, and that is this idea that things go to trial and that a prelim, it's like a mini trial, and those are questions for a trial. The reality is that about 98% of felony convictions, of cases that end, felony cases that end in convictions, do so by way of plea. There is never a trial in almost 98% of cases. There's a myriad of reasons for that we don't need to talk about today. But my point is that when you say that it's okay to use hearsay in whole or in part, but at a stage, that's the only stage that most cases even get to. They don't go beyond a preliminary hearing. Maybe they have a motion hearing or something like that. But in 98% of the cases, those questions that we thought were going, that in theory would be decided by 12 people, that's not how it happens. And so it is at the preliminary hearing stage that both sides are able to see how their, the complaining witness is, or the eyewitness, or how good is Annie's eyesight, that sort of thing. That takes place at a preliminary hearing, if there is one. A lot of people waive, but if there is one, that's the time when these things are sorted out, and that can actually prompt negotiations. When you read the reports, when you watch, police read reports, that's not giving you any new information about ways to resolve a case for either side. So that is another thing that's very concerning to me. And I guess one last comment I'd want to make is I didn't see the testimony about Wisconsin and the feds soon enough to do my own research. So I don't know if in Wisconsin they have some additional safeguards or processes that are afforded to criminal defendants, or the feds, like maybe there's some sort of rules or limits on hearsay. I don't know. But in our written testimony, we do list out that if this is something that you consider moving on, that you consider some of the ways to sort of mitigate the damage that could occur, or the negative effects that could occur. And so I guess one of those things is I'd be interested to see, are there safeguards? Sorry, I'm looking off at my testimony. Are there safeguards in the states or in the federal system that we should include? But also in our written testimony, we talk about if you're going to admit hearsay, I think that's a good idea that Representative Wheeler had about the sunsetting. But there's also, maybe there's ways to have an additional baseline of reliability of a certain statement. maybe we make criminal depositions more accessible to defendants, things like this we set out in our testimony, and I'd be interested to see whether those things exist in other states. I think that's mostly what I wanted to say, other than this final note, which is I feel like I've watched this committee be concerned last year with the speedy trial suspension. I feel that I've seen members of the legislature express concern over the last 2 years about encroaching on rights or good policy because there's a pandemic. And I understand there's a balance to be struck there, but I would just encourage folks to not dismantle this 60-year-old process. I guess what I'm saying is I'm just would ask you to move cautiously on this. And thank you for your time. I appreciate the opportunity, and I'm happy to answer any questions whenever the time's right.
Any questions? Representative Hobson.
Thank you, Mr. Chairman, and thank you for your testimony. You talked about the putting in safeguards per se, and I think I've heard Mr. Watson talk about safeguards in terms of having a sunset. What would you, if this law was to, to go through, what would be your recommendation in terms of the sunset we should put on this, for us to come back and review it, make sure that, everything is A-okay, make sure that we're not actually crippling anyone's rights, defendant rights, or holding up prosecution's proceedings. So what would you think your recommendation in terms of putting a sunset, how long should we put it on? That's my question.
Well, I guess I'd have to think about that, especially since I'm reluctant to say I would want a sunset. I mean, that I want this at all. To me, I feel like the thing that could really solve the problems set out here is more along the lines of using remote testimony, that could solve a lot of the problems and not present some additional ones that admitting hearsay would. But to answer your question, I mean, I don't know. I mean, maybe it's a year, maybe it's 2. But I'm not that excited about it. But I can appreciate that that's better than no sunset.
Mr. Watson, can I ask the same question as well? What was your recommendation, if I can, Mr. Chairman, what is your recommendation in terms of putting a sunset on this? Thank you, Mr. Chairman.
I think a 2-year period of time would be reasonable. I think that would allow the legislature to gather a fairly significant amount of data to see how the law was working.
Thank you, Mr. Chairman.
Additional questions? Representative Carmichael, is your hand still up? It is up. Representative Carmichael.
Thank you, Mr. Chairman. Ms. Roth, thank you for being here once again to testify on this legislation. I must confess to you, I have not had an opportunity to read your testimony this time around. I read it carefully the last time or 2 around, and I doubt that it's much different now because it's the same idea. That being said, let me address this matter of a sunset. Let's say it's only a year. What good is that to a defendant who sits in jail after a pro forma preliminary hearing, who doesn't get a right to examine the blind eyewitness until the trial? Does it do that defendant any good to make it a 1-year or a 4-year sunset? Or are they still stuck in jail awaiting the day when they finally get to cross-examine the witness against them? Does that sunset do them any good?
Well, no. And furthermore, I guess I would just go back to the other point I made, which is I'm guessing that in reality, and granted, I'm out of the trial level game at this point, but I do read cases from all 105 counties. But I would go back to my point of this. I bet in reality what happens is that person never actually questions Annie, and they try and they plead to something to get out or whatever. And the fact is that whether you're in a pandemic or not, that's the other thing. When I tell you 98% of cases end in pleas, I'm talking about pre-pandemic. And so you're right, the sunset doesn't help that person. And I'm not sure that person ever really gets their day to sort out all the evidence and likely, becomes a statistic of another person that it just led to something.
By the way, I should add for the committee's benefit that my neighbor Annie, as far as I know, she has very good eyesight, and I do appreciate her keeping her eye on my house when I'm out of town. That being said, one of the other arguments, though, that we heard is that information from, say, the breathalyzer operator is just all kind of foundational. We just take it all as gospel, and we don't really need to cross-examine the person who actually did the field sobriety test or the blood alcohol test, either one, that this is all just pro forma. We just ought to bring it right on into court. And the reason this concerns me is I've spoken to several defense lawyers this morning and yesterday afternoon, and everything they told me would be hearsay upon hearsay, so I won't share it with the committee because it's unreliable and not subject to cross-examination. But in an instance where the breathalyzer was messed up, either it wasn't calibrated or the procedures weren't followed, or heaven forbid that the report should be lost. I've been told that it's actually a benefit to the prosecutor to take a test run on some of these cases. And when the testimony falls apart at a prelim, the prosecutor, the judge doesn't bind the defendant over, jeopardy doesn't attach, the state then has more time to go out and look for and clean up their evidence and find a witness who does have good eyesight, who was across the street that saw Johnny breaking into my house. But if we don't have a prelim, they don't find out that they have big flaws in their case until a jury is impaneled and until jeopardy has attached. Then the case falls apart and the guilty goes free. Can that happen?
I don't know why not. And that is one of the things that we point out in our written testimony. And again, I understand that Mr. Watson practices one way, where he probably won't have things backfire on him, because he is going to, see how his witnesses would, and that sort of thing. But that is a concern, is that allowing hearsay can actually backfire against the state, against the prosecution, when you don't know how your witness is going to do, or how your evidence is going to hold up, or how your officer is going to look, and things like that. And so this idea that somehow or another that would be an efficiency, or would something like that, I would argue that it could be the opposite result, and that's not discovered until it's too late. So yes.
Mr. Chairman, I sure hope that this committee doesn't put efficiency ahead of justice. Thank you, Mr. Chair.
Any further questions? Thank you, Jennifer. We'll now move on to Eileen Burquist. Patiently waiting.
Thank you for having me today. Again, Eileen Burquist. I'm with the ACLU of Kansas. It is harrowing to hear about Representative Carmichael's rash of break-ins by some kid named Bobby. I'm glad your neighbor's checking in on you. I believe a lot of our points have already been made here today, but I would like to emphasize something that I don't think has received quite enough attention. Specifically, the ACLU's position is that the use of two-way electronic communications in this context is a violation of the Sixth Amendment's Confrontation Clause. The Sixth Amendment guarantees that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. As was mentioned before, it's a hallmark of our criminal legal system, and has been called the greatest legal engine ever invented for the discovery of truth. Finally, the Confrontation Clause allows the finder of fact, whether that's the jury or the judge, to observe the demeanor of the witness in making his statement, thus aiding and assessing credibility. So we've spoken a lot about being able to ask about eyesight or all of those questions, but credibility and the demeanor is also incredibly important, and that can be damaged by the use of two-way audio video. It has been found in two recent state Supreme Court cases. In 2020, the Michigan Supreme Court found in People v. Jimison that the use of two-way audiovisual testimony by a witness violated this confrontation clause. And just last month, the Missouri Supreme Court reversed a conviction on these grounds that the permission of witness testimony via live video violated the confrontation clause. So for these reasons, we ask that you not pass this bill, and I would refer you to my testimony for any resources or more information.
Any questions, committee? Representative Curtis.
Thank you, Mr. Chairman. I just want to make sure I understand. So you're saying, and thank you for your testimony, but you're saying that the way that the bill is currently written, that if it were to be challenged, it would perhaps be unconstitutional?
Perhaps. I can't speak to what would be decided in the Supreme Court, but that is the very real concern that was brought to us by our attorneys.
And that's based on case law that
Yes,
has already been settled?
correct.
Thank you. I just wanted to make sure I understood. Thank you.
Representative Carmichael.
I do think, however, though, Ms. Burquist, we could agree that that confrontation clause, as the Assistant District Attorney says, at least constitutionally applies at the determination of guilt or innocence stage, not necessarily at a preliminary stage in the proceedings. Is that your understanding of the law as well?
I think that the argument could be made that it stands with the preliminary hearing as well. But I would be happy to follow up with you if you want us to find some case law on that,
I'll
see
be
if it
honest
exists.
with you. Go ahead, I'm sorry.
No, that's fine. Go ahead.
I'm sorry. I'd have to probably, if I was the lawyer, I'd rather have the other side of that argument because I think it's pretty clearly established that what they propose here, you don't even have to have a video link. The confrontation clause probably isn't applicable at this stage, and since I can't see how video or lack of video would it really affect the matter. If we were talking about a video statute at a trial in front of a jury, then it may well implicate the confrontation clause. If you see it differently, I hope you can persuade me otherwise, because I wish it were the law that this applied at all stages of the criminal proceeding.
That was the understanding when we put this testimony together, is that this would apply at the preliminary stage. But if you'd like us to follow up with some case law or understanding about that from our attorneys, I'd be happy to do so.
Now, that's not necessary. What I was really looking for was a case that would have said that the confrontation clause applies at preliminary hearings, and I think the answer to that is probably no, except in states like Kansas, which give their citizens a right to confrontation at a preliminary hearing. Thank you, Mr. Chair.
Any further questions? Okay, thank you.
Thank you.
Anyone else here or online as an opponent? Not seeing any, we'll close the hearing on House Bill 2538, open the hearing on House Bill 2508, and have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2508 would require retention of fingerprints by the Kansas Bureau of Investigation for participation in the federal RAP-BAC program. The bill enacts a new section of law that would require an applicant, employee, or volunteer who's subject to a criminal history record check to provide the requesting authorized entity with consent to obtain that person's fingerprints to conduct that record check and to participate in the RAP-BAC program for the purpose of determining suitability or fitness for a permit, license, employment, or volunteer service. An authorized entity would be required to notify each person subject to a record check that the fingerprints will be retained by the KBI and by the FBI for all current and future purposes authorized for fingerprint submission. And they would also have to be notified when fingerprints are going to be enrolled in the RAP-BAC program. Fingerprints will be searched against known criminal fingerprints to determine if criminal history record exists, and also against latent fingerprints entered into the unsolved latent fingerprint file. A criminal history record check shall only be completed for the purpose for which the check was requested. Any additional record check would require an additional set of fingerprints to be submitted. An authorized entity enrolled in the RAP-BAC program shall immediately notify the KBI when that entity is no longer entitled to receive criminal history record information relating to a particular person enrolled in RAP-BAC. The KBI would then cancel the enrollment and updates to the criminal history record information and no longer provide them to that entity. Fingerprints and related records acquired by the KBI shall be available only to authorized entities entitled to obtain that information. No employee of the KBI shall disclose such records to any person not authorized to receive them. And then the bill also provides for definitions of those authorized entities of a criminal history record check and the RAT back program. And I can take any questions.
Any questions? Representative Wheeler.
Just be real quick, just so I understand. Is this suggesting that the KBI does not presently or historically keep custody of the fingerprints that it receives?
I'm going to let Robert with the KBI address that in his testimony.
Thank you.
Any other questions? Thank you, Natalie. Representative Humphreys.
Thank you, Mr. Chairman. Did you explain what the RAT back program was?
I'm sure
Okay,
that
that's
Robert's
great.
going to kind of
Okay.
get into detail about
Okay,
that.
thank you.
Okay, thank you, Natalie. We will start with proponents, and Robert Jacobs is here today.
Thank you, Chairman Patton and members of the committee. My name is Robert Jacobs. I serve as the Executive Officer with the Kansas Bureau of Investigation. I'll start by answering the first question to Representative Wheeler. The KBI does currently retain fingerprints that are submitted through requests for criminal history record checks. This statute, the premise of this statute is actually to clarify in law and in statute the retention of those fingerprints. We've had several legal analysis over the years determining that we can keep those fingerprints and retain those fingerprints, especially for the purposes of RAT back, and I'll get into what RAT back is. But so far, we would much rather have in statute some clarity to the fact that we are retaining those fingerprints. And I've submitted my testimony, and you have my written testimony, so I'll avoid some of that. And I know we're short on time too, but what I do want to mention is that the KBI does have and has been instilled with the responsibility of maintaining the state's criminal history records. We have criminal history records that go back many, many years. We offer, the KBI offers criminal history record checks to both criminal justice and non-criminal justice entities. Some of those entities for criminal justice would include candidates for sheriff, police chiefs, some certifications that occur through the Kansas Law Enforcement Training Center or the Kansas Seapost. All of those can and have been utilized the record checks to determine whether an individual is appropriate for their certification or their office. On the flip side, we also do this for non-criminal justice agencies as well. Many of these requests are done because an individual is either applying for an employment position, a volunteer position, or just to work in a position of trust. And so those positions may be financial in nature, or they may be around our vulnerable populations, whether that's children, the elderly, or people with disabilities. So what happens is we actually have, the state has about 80 statutes that authorize criminal history record checks. Many of those are just name checks only, but 58 of those statutes all pertain to fingerprint record checks for civil reasons. So we provide that service. To get a criminal history record check, you have to supply, an individual would have to supply their name, their date of birth, and their fingerprints. This is typically done through an authorized entity. That may be the Department of Education, it may be the Department of Labor. They would apply for a position with those. That entity would require that they submit to a criminal history record check, and they would submit those fingerprints to the KBI. Once those are submitted, we will give them what's considered a rap sheet, a sort of a snapshot of what their criminal history is at that particular moment in time. And they would get that back to determine eligibility for whatever position they are applying for or job that they're working towards. So the Rap Back program is a program that occurs after that initial request for a criminal history record. So once that record is returned to them, that entity, that authorized entity, has the ability to enroll that individual in the Rap Back program. And the Rap Back basically does a continuous monitoring of fingerprints to determine whether or not there's been a change to an individual's criminal record. If there has been, the Rap Back system will notify that authorized entity that there has been a change to the record. Well, there are some safeguards to that, and I'll talk about that here in a minute. But that process allows that authorized entity to become aware of arrests and convictions of the people that they have working for them or volunteering for them, that are in those positions of trust much quicker than they would find out if it was a situation where they were waiting for conviction, which could be a year later or more. So it's sort of a safeguard for that group to know who the individuals that are working for them, if they've been involved in some sort of a criminal activity. So currently, Kansas has the ability to operate the Kansas Rap Back system. We have an AFIS system. It stands for Automated Fingerprint Identification System. When fingerprints are submitted to the KBI, those fingerprints are run through AFIS, and they look to see if there's any crimes that occurred that are within AFIS or any matches within the AFIS system. Because of our limited capabilities of our current system, we can only operate Rap Back for any offenses or crimes that occur in the state of Kansas. So any entity that wants to enroll in Kansas Rap Back, if a subsequent arrest or conviction occurs with one of their individuals, and it occurs in Kansas, we can notify that authorized entity that there's been a change to the record. We do not, unfortunately, have the ability to participate in the FBI Rap Back system, which is a national system that looks at arrests and convictions all over the United States. However, in 2020, the KBI requested funding through the legislature to improve our AFIS system. We received that funding, and we will soon be implementing what's now called the Automated Biometric Identification System, or ABIS. ABIS will come online in 2023, and with the new ABIS system, we will be able to participate in the FBI Rap Back system, which will provide much more coverage for those authorized entities who are interested in knowing about their employees and their volunteers. Currently, with the Kansas AFIS system, the KBI charges a $3 charge for everyone enrolled in Rap Back. Once FBI comes online, the KBI anticipates that we will remove that $3 charge and there will be no need for that anymore. That will probably end up having a loss of about $500,000 to the agency, but we believe it's still the right thing to do. The FBI system will encompass the Kansas system. So those services will not cost anything after that. Finally, once the FBI system is in place, we will be able to notify those authorized entities of any change in record. I do want to get back to the safeguarding that I mentioned before. The way that works, if there is a change in record, the first thing that the FBI will do, the Rap Back system, it will notify the Kansas system. The Kansas system will then turn around, the KBI will then turn around and notify that authorized entity that there's been a change in their record of an individual, and we will ask them whether or not they still have they're still entitled to that criminal justice information. So there could be situations where a person goes to work for Department of Labor, they submit their fingerprints, they're entered into Rap Back, and a year later they leave that position with Department of Labor. And then a year after that, they're arrested in Colorado. That record would then, that fingerprint would then get sent to the KBI. That notification, we would contact Department of Labor, but before we give them that information, we want to make sure that they're still entitled to it. So that's a safeguard that's kind of put into the wrap-back system. So ultimately, we appreciate and we would encourage your support of this bill. We believe that it accomplishes many things. First off, it will require authorized agencies to notify their people and the applicants that the KBI is retaining their fingerprints. It will also provide, it will also require them to let them know if that entity is going to submit or enroll that individual in the wrap-back program so that they are aware of that. And then finally, it also requires that entity to notify the KBI if at any point they are no longer entitled to that criminal history record for that individual. So we can remove them from the system and we don't have them in the system any longer when we shouldn't. The other thing that I wanted to make mention of, and just finally, we believe that this bill is important. We want to try and get it passed this year. The FBI has notified us and told us that if we do not change our language in our statute to make sure that we are notifying individuals of enrollment in wrap-back, they will not let the KBI participate or Kansas participate in the wrap-back program. So the language in the statute is very important for us to be able to continue to protect our vulnerable populations around the state. And we hope that you'll see that we should be changing this language to allow KBI and to enroll in the FBI wrap-back system in 2023 when it comes online. With that, I will be happy to stand for questions.
Any questions? Representative Schreiber.
Thank you, Mr. Chairman. Just so I understand, so if I take a job remotely, say with someone in Ohio or Kentucky, somewhere there that requires my fingerprints, and then, but I reside still in Kansas, and then I am convicted of criminal activity here, there's no way that that arrest would, or through my fingerprint information, be available to those out-of-state agencies that I'm employed by?
Well, so it's all going to rest on and I appreciate your question. It's all going to rest on that authorized entity, who you went to work for. If they have the ability to put your fingerprints in through the Ohio system, and they are participating in the FBI wrap-back, if you are arrested here in Kansas, it would notify them in Ohio that you've been arrested here in Kansas.
But if they weren't an authorized entity for Kansas, then it would be.
That's correct. These are my understanding is these are solely for state agencies, state entities that participate in the Kansas and the within Kansas of the wrap-back system. Every state has their own system, in other words.
All right. Thank you.
Yes, sir.
Representative Humphreys.
Thank you, Mr. Chairman. So what makes someone an authorized entity?
There's several statutes. There's 58 statutes that allow for an agency to be to receive criminals.
Those are state statutes.
Yes.
But you mentioned that if someone goes to work in Colorado, and you said if they're an authorized entity, then they would be. You said something, and so that's separate than Kansas. What makes them authorized in Colorado?
Okay, I apologize. Maybe I was unclear, and let me see if I can clarify that. So, with the state and the wrap-back system in Kansas, the state agencies that are allowed to, and entities that are allowed to participate in wrap-back are all subject and all, I'm trying to think of the right way to say this, but are all related to the state of Kansas. if you work for one of those agencies, in Department of Labor, Department of DCF, whatever it may be in Kansas, and they to get employed here, you submit to fingerprints. We submit that, and then they enroll you in RATBAC. The authorized entity then enrolls you in RATBAC. That's a Kansas entity. You then, not related to an employment, but you then are in Colorado on vacation and you get arrested. Under the FBI RATBAC system, your authorized entity here in Kansas would be made aware of your arrest in Colorado. So this system is only based on people who are working here in Kansas, and the authorized entities are all related to Kansas.
And so, and then you say that this bill requires the authorized entity to notify the applicant that, and also it requires the authorized entity to notify, well, first of all, that the FBI is retaining their fingerprints.
Yes, ma'am.
And so is that like, I had my fingerprints taken 10 years ago, and so now if we pass this bill, I'm going to be notified that the KBI is keeping my fingerprints?
So the KBI has been keeping
I clearly don't.
So, and I apologize. The KBI has been keeping
I
fingerprints.
know they've been keeping it, but they haven't, but now they're going to have to notify me that they're keeping them?
So upon your initial request for your position, whether that's to work for the Department of
Join the Kansas Bar.
KDH&E, pardon?
Join the Kansas Bar.
Okay, to join the Kansas Bar. When you first apply to do that, they're going to say, we need to take your fingerprints for a criminal history record. This bill will just basically say that they are required now, when you apply, to tell you that once you submit your fingerprints on that initial application, that the KBI is going to retain those fingerprints. And if that entity, the Bar Association, is going to enroll you in RATBAC, they're required to tell you that they're going to do that.
But is it retroactive? When I joined the Kansas Bar years ago, are they now going to have to tell me that they're joining the RATBAC program?
That is a great question, and I honestly don't know the answer to that. I will find out the answer for you. I don't believe it is retroactive, but I also have Leslie Moore here with me, who's the division director and of our Information Services Division, and she may be able to answer that question, if with your permission.
Absolutely. Come on up.
Oops.
Thank you. I'm Leslie Moore, as he said, with the KBI. I'm the Information Services Division Director. All of this is ran in my division. We haven't had anybody ask us to be retroactive, but I do know that this has occurred in the state of Texas, where they've had an agency that had been doing their state RATBAC for many years ask if they could put everybody retroactive. The FBI made them contact every single one of those people that they were going to retroactively put in the FBI RATBAC program before they were allowed to do it. So those people had to give their permission for that to happen.
So not just notice, it was, they had to affirmatively
They did.
agree. Okay. All right, thank you. Just, Mr. Chairman.
Representative Curtis.
Thank you, Mr. Chairman. First, I want to make sure, you're saying RAP back, right? WRAP?
Yes, ma'am. It's,
Okay, thank you.
It stands for records and, I'm sorry, it stands for records, arrest, and prosecution.
So it's
RAP,
REP.
RAP,
RAP.
and then back.
Just wanted to make sure I had that right, because I was hearing something else that would not be good for calling this. How many states participate in the FBI RATBAC program?
Again, I may have to refer to Ms. Moore. I'm unaware of how many states are involved in it. I believe every state has at least a state RATBAC system. How many are associated with the FBI? Maybe 4. And part of that might also be based on the ABIS technology. With the new technology with our ABIS system, as other states are bringing ABIS online as well, we might see that FBI program grow.
Okay. And then okay, Mr. Chairman, I have just a couple of follow-ups. So I'm just trying to understand, like, once we participate in the FBI program, say somebody is employed here as a school teacher, they're part of the rep back program, so they're being monitored, their record. What happens if they go to another state that is also part of the federal program? Is that information then interchangeable? Say they go from here, say Colorado's in it, they apply, they're a they move from a school teacher here to a public school teacher there, all in part of that monitoring program, then does that continue to follow them?
Sure. From my understanding, once they were to leave the, let's say, Emporia school system, school district, or actually be the Department of Education. The Department of Education would no longer have them in their wrap-back system. They would be required to notify the KBI that they're not entitled to that criminal history record anymore, and then they would be removed from our system. If then they go to Colorado and become a teacher there, if the Colorado Department of Education participates in the FBI wrap-back system, they would in essence have to go through that whole process again of they'd be submitting their fingerprints and then would be enrolled if they felt that if the Department of Education did that.
So it basically the process would start over for that person then?
Yes, ma'am.
Okay, and then one last question. How do you then, in this system, handle records that have been sealed from public view, for example, expungements?
So some authorized entities, and this is a great point because currently, if an individual were to, for example, request to become a teacher through the Department of Education, and they had their criminal history, they submitted their fingerprints and had their criminal history record run, and then they're enrolled in wrap-back. If then a month later they said, hey, we'd like to also become a concealed carry individual, can you just run you already have my fingerprints? We actually cannot do that. We have to have another set of fingerprints submitted. If they were to do that at the same time, submit that and say, I want it for Department of Education and concealed carry, it would be a little bit more feasible to make notification to both of those groups. But one of the reasons that we can't do it separately is if, for example, we provided Department of Education that information, and then they said, I would like to have concealed carry. First off, we have no way of knowing who that person is who's calling us. So we have no way of verifying that they are really who that person is. Fingerprints help with that. But more importantly, Department of Education may be entitled to certain information that concealed carry is not, including expungements. Some of the authorized entities want convictions that have occurred within the last 12 months only. Some want all convictions. Some want convictions in both adult and juvenile convictions. So based on the statute, it kind of determines what level of authorization they have. And each authorized entity will have their own personal disqualifiers. So if, for example, Department of Education, if I was arrested for battery of a child, that may be a disqualifier, and I can't get a job as a teacher. Whereas another entity, Department of Revenue, may not have that as the same disqualifier. So that's another reason why we can't just give that information out, kind of carte blanche to everyone. Each agency has or entity has kind of their own specific allowances of what they can obtain. I hope that answers your question.
Representative Hobson.
Thank you, Mr. Chairman. My question is with respect to states, let's say, for instance, here in Kansas, and we put the fingerprints and, have the record of someone, and say, for instance, they move to Texas to work for another state agency. What if it's vice versa? Say, for someone from a state that participates, maybe from Texas, moving here, do you guys have access to their information as well, or will they have to come in and just do a whole brand new set of, fingerprints per se?
Yes, sir. Thank you. So we have some access. It's not far-reaching. So, for example, Missouri has an MOA or an agreement with Kansas to share fingerprint information. But even in those situations, if, for example, there's a hit through the APHIS system on a criminal case in Missouri, and they match it to a civil fingerprint in Kansas, we will not give them information about that civil fingerprint. It may match and they may be aware of it, and they'll ask us, but we don't give out that information. And that occurs actually vice versa too. So to answer your question, if they were to move from another state into Kansas, once again, that whole process would start all over again. If they took a position, a new position in Kansas with one of the authorized entities, then we would have to have them submit their fingerprints, and then that entity may enroll them in RATBAC.
Thank you, Mr. Chairman. Thank you. Mr. Chairman.
Any additional questions? Thank you, Robert.
Thank you.
Anyone else here as a proponent? Any neutral? Anyone as an opponent? Okay, closing the hearing on House Bill 2508. Thank you, everyone. No meeting tomorrow. Losing track of what day of the week it is, but I think it's Friday, so we won't be here Friday. We do, if you've seen the agenda, have a busy week next week, and we will that last week as well. So be ready for that. Look at the list of bills coming up and try to be ready for those. While Thursday says, I think it says meeting pending, agenda to be announced, we will be hearing that hospital worker protection bill that Representative Featherson's trying to figure out how to get introduced. We will hear that on Thursday. Likely going to try to work some bills Wednesday and then spend the rest of the time Thursday getting caught back up since we didn't have the ability to work bills this week. So that's all I've got. Everybody have a safe trip home, and we'll see you soon.
Mr.
Yes, Representative Keither.
Yeah, I would just like Representative Carmichael to know that he's made me feel really guilty, and I now need to make an eye appointment with my doctor so I can make sure I'm saying things properly. Thank you, Representative Carmichael.
My pleasure, Representative, and despite the allegations made by the speaker and others, I am not drinking scotch until after I hear the chairman say the word adjourned.
You're out of cigarettes, though. Okay, we are adjourned.